Second Amendment. Joseph Story, a Supreme Court justice in 1833, famously stated,
"The right of a citizen to keep and bear arms has justly been considered the palladium of the liberties of a republic, since it offers a strong moral check against the usurpation and arbitrary power of rulers, and will generally, even if these are successful in the first instance, enable the people to resist and triumph over them."
Understanding the Second Amendment. To fully grasp the meaning of the Second Amendment, we must analyze it through two primary interpretive lenses: textualism and originalism. While these approaches are often conflated, they represent distinct methods of legal interpretation. Textualism, championed by jurists like Justice Antonin Scalia and Justice Hugo Black, argues that the Constitution should be interpreted based on the plain meaning of its text. As Scalia put it, it is the law that governs, not the intent of the lawgiver. Originalism, on the other hand, focuses on understanding the Constitution based on the original intent and context of its framers. Since textualism is more commonly invoked, we'll begin our analysis with that approach. Textualism and the grammar of the Second Amendment. The text of the Second Amendment reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." One challenge with a purely textual approach is the interpretation of grammar and punctuation, particularly the significance of the commas. However, J. Neil Schulman sought clarity by consulting Professor Roy Copperid, an expert on English grammar. Their discussion, summarized here, helps demystify the amendment's structure.
Does the Second Amendment grant the right to keep and bear arms solely to a well-regulated militia?
Copperid.
The sentence does not restrict the right to keep and bear arms, nor does it state or imply possession of the right elsewhere or by others than the people. It simply makes a positive statement with respect to a right of the people.
Is the right of the people to keep and bear arms granted by the Second Amendment, or does the amendment assume a pre-existing right?
Copperid.
The right is not granted by the amendment, its existence is assumed. The thrust of the sentence is that the right shall be preserved inviolate for the sake of ensuring a militia.
Is the right of the people to keep and bear arms conditioned upon the necessity of a militia?
Copperid.
No such condition is expressed or implied. The right to keep and bear arms is not said by the amendment to depend on the existence of a militia. The right to keep and bear arms is deemed unconditional by the entire sentence.
This analysis reinforces the idea that the Second Amendment assumes a pre-existing right to bear arms, and that this right is not contingent on militia service. In the landmark case, District of Columbia v. Heller, 2008, the Supreme Court, in its majority opinion, echoed similar conclusions. The court ruled that the right to bear arms was unconnected to militia service, and that the Second Amendment protects an individual's right to possess and carry firearms for lawful purposes, such as self-defense. Justice Scalia wrote,
"There are a few examples, all of which favor viewing the right to keep arms as an individual right unconnected with militia service. Keep arms was simply a common way of referring to possessing arms for militiamen and everyone else. Every late 19th century legal scholar that we have read interpreted the Second Amendment to secure an individual right unconnected with militia service."
Additionally, the court noted that the right to bear arms pre-existed the Second Amendment.
It is dubious to rely on the drafting history to interpret a text that was widely understood to codify a pre-existing right, rather than to fashion a new one.
The court further clarified that the Second Amendment was not primarily about hunting.
If bear arms means, as the petitioners and the dissent think, the carrying of arms only for military purposes, one simply cannot add, for the purpose of killing game. The right to carry arms in the militia for the purpose of killing game is worthy of the Mad Hatter.
Thus, the ruling in Heller affirmed that the Second Amendment guarantees the right to possess firearms for self-defense and other lawful purposes beyond military service. D.C. v. Heller, 2008. The Heller case revolved around a challenge to a Washington, D.C. handgun law that made it illegal to carry an unregistered handgun and required that firearms kept in the home be disassembled or locked. Dick Anthony Heller sued the District of Columbia, claiming that the law violated his Second Amendment rights. The Supreme Court ultimately ruled in Heller's favor, striking down the D.C. law as unconstitutional. The Heller decision was celebrated by gun rights advocates for affirming the individual right to bear arms. However, the ruling also left the door open to certain forms of gun control, as Justice Scalia acknowledged that the right to bear arms was not unlimited.
Like most rights, the right secured by the Second Amendment is not unlimited. Nothing, in our opinion, should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings.
This acknowledgement led to critiques of the Heller decision, as it suggested that government regulation of firearms was still permissible. Attorney Suzanne Sherman pointed out the inherent contradiction in Scalia's reasoning.
To claim a right is so sacred that the government may not infringe upon it, but to then say the government has the authority to regulate the very same right is inherently contradictory.
Scalia's opinion in Heller also raised questions about the definition of arms.
The term arms was applied, then as now, to weapons that were not specifically designed for military use and were not employed in a military capacity.
This interpretation deviates from historical understandings of arms as including military-style weapons. As we've discussed earlier in the history of bearing arms, the term arms traditionally referred to military weapons, and during the time of the founders, there was no such distinction between military-style and civilian firearms. James Madison argued for interpreting the Constitution as it was understood at the time of ratification.
I entirely concur in the propriety of resorting to the sense in which the Constitution was accepted and ratified by the nation. In that sense alone, it is the legitimate Constitution. If the meaning of the text be sought in the changeable meaning of the words composing it, it is evident that the shape and attributes of the government must partake of the changes to which the words and phrases of all living languages are constantly subject.
Despite these contradictions, the Heller decision reinforced the individual right to bear arms, albeit with certain limitations. Individual versus collective right. Some argue that the Second Amendment protects a collective right rather than an individual one. However, the structure of the Bill of Rights suggests otherwise. Both the First Amendment and the Fourth Amendment refer to the right of the people, which has been understood to apply to individuals. For example, the First Amendment,
Congress shall make no law abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble.
Fourth Amendment,
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures.
If we were to interpret the Second Amendment as only protecting a collective right, we would have to apply the same logic to these other amendments, which clearly protect individual rights. Legal scholar David Vanderkooy echoes this sentiment by citing Blackstone's commentaries.
Blackstone described the right to keep arms as absolute or belonging to the individual, but ascribed both public and private purposes to the right. The public purpose was resistance to restrain the violence of oppression. The private was self-preservation.
The Second Amendment, like the rest of the Bill of Rights, protects individual rights, and any interpretation suggesting otherwise undermines the core principles upon which these amendments were based. History of bearing arms. To truly understand the Second Amendment, we must explore the history of bearing arms. The right to bear arms predates governments and is closely linked to the natural right of self-defense, as discussed in the chapter on natural law. However, this section will move beyond natural rights and delve into the historical development of the right to bear arms in constitutions, articles, and charters. While many may believe that the right to bear arms is uniquely American, it actually predates the Second Amendment by centuries. In his work Politics, Aristotle wrote in the 4th century BC that the ownership of weapons was necessary for true citizenship and participation in the political system. He saw the bearing of arms as essential for those who govern themselves, emphasizing that political participation required the ability to defend oneself and the community. Marcus Tullius Cicero, in De Officiis around 44 BC, similarly advocated for bearing arms, not only for individual self-defense, but also for public defense against tyranny. Centuries later, the Assize of Arms of 1181 provided one of the earliest legal frameworks for bearing arms, offering a glimpse of what would eventually become the right to bear arms in English law. Signed by King Henry II, this law permitted the carrying of arms for self-defense and mandated that every freeman be ready for military service, thus creating a militia system. This system had parallels to the earlier Anglo-Saxon fyrd from around 605 AD, where free men and tribes were obligated to serve in the militia. The connection between freedom and bearing arms was so strong that a former slave being granted freedom was ceremonially given the arms of a freeman. The Assize of Arms outlined the minimum requirements for arms ownership based on social rank. For example,
let every holder of a knight's fee have a hauberk, a helmet, a shield, and a lance, and let every knight have as many hauberks, helmets, shields, and lances as he has knight's fees in his demise.
this was not unlike the Militia Act of 1792 in the United States, which required citizens to own
a good musket or firelock, a sufficient bayonet and belt, 2 spare flints, knapsack, a pouch, proper powder and ball.
King Henry III expanded the Assize of Arms in 1253 to include all men between 15 and 60 years old, mandating that even the poorest citizens be armed. David T. Hardy highlights that these citizens were required to possess weapons such as halberds, knives, and bows. Later, Edward III continued this tradition by requiring Englishmen to practice archery regularly, as it was deemed essential for the defense of the realm. Every town was mandated to maintain an archery range, and Englishmen were required to own a bow of their own height. During this period, the longbow was one of the deadliest weapons on the battlefield, and it was considered so essential that crossbows and firearms were banned in the 16th century, not out of fear, but to ensure that Englishmen remained proficient with the more effective longbow. Under Queen Elizabeth I in the 16th century, the term militia first appeared to describe the concept of a universally armed populace prepared to defend the nation. However, from James I in 1567 to James II in 1685, England faced disarmament, military rule under Oliver Cromwell, and the erosion of individual rights through the rise of standing armies. This culminated in the Glorious Revolution of 1688, which restored the right to bear arms and led to the Declaration of Rights in 1689. One of the key grievances against James II was his disarming of the populace, and the Declaration of Rights stated,
"The subjects which are Protestant may have arms for their defense, suitable to their conditions, and is allowed by law."
This wasn't a declaration that only Protestants could bear arms, but rather an acknowledgement that Catholics had already been armed under previous laws. The importance of the right to bear arms was echoed by Granville Sharp, the English abolitionist, who wrote,
"No Englishman can be truly loyal who opposes the principles of English law whereby the people are required to have arms of defense and peace, for mutual as well as private defense. The laws of England always required the people to be armed, and not only armed, but to be expert in arms."
In the American colonies, these principles were deeply ingrained. Colonists in Virginia were required to bring their firearms to church for military musters, similar to the English tradition. Other colonies implemented laws mandating that all free men be armed and ready for service, such as this statute.
Every free man or other inhabitant of this colony provide for himself and each under him able to bear arms, a sufficient musket, and other serviceable piece for war.
Notably, these laws referred to firearms as pieces of war, reinforcing that arms were considered essential for both personal defense and collective security. By the time the Second Amendment was written, 8 states already had constitutions that included a right to bear arms. It was considered common sense that citizens could possess arms for self-defense in defense of the state. For example, the Winchester Gazette in 1788 noted,
There are other things so clearly out of the power of Congress that the bare recital of them is sufficient. I mean, rights of conscience or religious liberty, the rights of bearing arms for defense or for killing game, the liberty of fowling, hunting, and fishing.
The tradition of bearing arms was tied to a strong opposition to standing armies and an enduring commitment to local militias. This historical context helps illuminate the original understanding of the Second Amendment, which was intended to protect the individual's right to bear arms for self-defense and to ensure a militia capable of defending the nation from tyranny. Standing armies. Throughout the history of the right to bear arms, we see the topics of militia and standing armies brought up repeatedly. Although militias are a common theme in discussions about the Second Amendment, standing armies receive far less attention. One reason for this may be that many gun owners are also strong supporters of the U.S. military. Ironically, those who often reference the founders' views are usually silent when it comes to standing armies, even though the founders specifically warned against them due to their potential to drive the nation into immense debt. The Second Amendment is intimately tied to countering standing armies, yet this aspect is often overlooked. Understanding the founders' views on standing armies is crucial to the Second Amendment debate. There are many shallow answers referencing British confiscation of arms and revolting against tyranny, with quotes like,
"We should not forget that the spark which ignited the American Revolution was caused by the British attempt to confiscate the firearms of the colonists."
This quote is often attributed to Patrick Henry, but there is no verifiable evidence that he actually said this. Regardless, this belief, whether true or not, has become the accepted answer. However, the Second Amendment is about much more than just this. The Second Amendment is a direct response to the threat posed by standing armies, something the founders frequently warned about. It specifically targets Article 1 of the Constitution. In an essay from February 29, 1788, titled "A Maryland Farmer," the author writes,
"It will be asked, how has England preserved her liberties with at least an apparent standing army? I answer, she did lose them. But as there was no standing army until lately, she regained them again. She lost them under the Tudors, who broke the then oppressive power of the aristocracy. But the unparalleled avarice of Henry VII, the boundless extravagance of Henry VIII, the short reign of Edward VI, which was but the sickly blaze of a dying candle, the bigotry of that weak woman Mary, who had no other object than religious persecution, and lastly, the parsimony of Elizabeth, who had no children of her own to provide for, and who hated her legal successor and his family, all conspired to prevent their establishing a military standing force sufficient to secure their usurpations. And the nation recovered from their paroxysm under the Stuarts, who were too weak and too wicked to command even respect, notwithstanding their dignity. On the Revolution in 1688, the patriots of that day formed some glorious bulwarks, which seem as yet to have secured them from the evils and danger of their present standing army, though still, in my opinion, they hold their remaining liberties by a very precarious tenure indeed, as the first enterprising and popular prince will most probably convince them.
The glorious bulwarks referenced here point to the Declaration of Rights, which granted English citizens the right to bear arms. In this letter, it is clear that John Francis Mercer, the probable identity of the Maryland farmer, and a member of the Constitutional Convention, as well as an anti-federalist, was explicitly warning about the dangers of the government creating permanent standing armies. At the time, there was no protection against this in the new American Constitution. Mercer continued,
"In England, by their Bill of Rights, a standing army is declared to be contrary to their Constitution, and a militia is the only natural and safe defense of a free people. This keeps the jealousy of the nation constantly awake and has proved the foundation of all the other checks. In the American Constitution, there is no such declaration or check at all."
Like many of the founders, Mercer feared standing armies. He, along with other anti-federalists, pushed for a Bill of Rights to safeguard against such threats by guaranteeing the right to bear arms, an idea mirrored in state constitutions. He pointed to various state declarations, such as Massachusetts,
"The people have a right to keep and to bear arms for the common defense. And as in time of peace, armies are dangerous to liberty, they ought not to be maintained without the consent of the legislature, and the military power shall always be held in exact subordination to the civil authority and be governed by it."
Pennsylvania,
"The people have a right to bear arms for the defense of themselves and the state, and as standing armies in the time of peace are dangerous to liberty, they ought not to be kept up. and that the military should be kept under strict subordination to and governed by civil power.
Maryland and Delaware.
A well-regulated militia is the proper and natural defense of a free government. Standing armies are dangerous to liberty and ought not to be raised or kept without the consent of the legislature.
North Carolina.
The people have a right to bear arms for the defense of the state. And as standing armies in time of peace are dangerous to liberty, they ought not to be kept up, and the military should be kept under strict subordination to and governed by the civil power.
These state constitutions highlighted the dangers of standing armies and the importance of armed militias as the primary defense against such forces. During Virginia's ratification debates, George Mason warned,
"Give me leave to recur to the page of history to warn you of your present danger. Recollect the history of most nations of the world. What havoc, desolation, and destruction have been perpetrated by standing armies. An instance within the memory of some of this house will show us how our militia may be destroyed. 40 years ago, when the resolution of enslaving America was formed in Great Britain, the British Parliament was advised by an artful man who was governor of Pennsylvania to disarm the people, that it was the best and most effectual way to enslave them, but that they should not do it openly, but weaken them and let them sink gradually by totally disusing and neglecting the militia."
Mason and others had just fought a war for independence and had witnessed the French Revolution. They also knew of England's Glorious Revolution a century earlier. Mason connected the two central premises of the Second Amendment, self-defense and defense against standing armies.
By these amendments I would give necessary powers, but no unnecessary power. If the clause stands as it is now, it will take from the state legislatures what divine providence has given to every individual, the means of self-defense. Unless it be moderated in some degree, it will ruin us and introduce a standing army.
Patrick Henry similarly expressed his concerns.
I was heard to say a few days ago that the sword and purse were the two great instruments of government, and I professed great repugnance at parting with the purse without any control to the proposed system of government. And now, when we proceed in this formidable compact and come to the national defense, the sword, I am persuaded we ought to be still more cautious and circumspect, for I feel still more reluctance to surrender this most valuable of rights.
Henry emphasized that the Second Amendment addressed the dangers posed by standing armies as much as it guaranteed individual rights. He questioned whether Congress could be trusted to arm the militia, warning,
"The great object is that every man be armed. But when this power is given up to Congress without limitation or bounds, how will your militia be armed? You trust to chance. For sure I am that nation which shall trust its liberties in other hands cannot long exist. But implication will not save you when a strong army of veterans comes upon you."
The debate over standing armies and their connection to self-defense was central to the founders' arguments for the Second Amendment. James Madison, the author of the Second Amendment, expressed his concerns during the Constitutional Convention of 1787.
A standing military force with an overgrown executive will not long be safe companions to liberty. The means of defense against foreign danger have always been the instruments of tyranny at home.
In Federalist 46, 1788, he further warned,
"The greatest danger to liberty is from large standing armies. It is best to prevent them by an effectual provision for a good militia."
Other founders echoed these sentiments. Tench Coxe, writing as a Pennsylvanian in the Philadelphia Gazette, 1789, noted,
"As civil rulers not having their duty to the people duly before them may attempt to tyrannize, the people are confirmed by the article in their right to keep and bear their private arms."
Later in Political Observations, 1795, Coxe expanded on this idea.
"Of all the enemies to public liberty, war is perhaps the most to be dreaded because it comprises and develops the germ of every other. War is the parent of armies. From these proceed debts and taxes, and armies and debts and taxes are the known instruments for bringing the many under the domination of the few. No nation could preserve its freedom in the midst of continual warfare."
Many other prominent leaders, from George Tucker to Samuel Adams, shared this belief. Tucker, in Blackstone's Commentaries, 1768, wrote,
"Wherever standing armies are kept up, and when the right of the people to keep and bear arms is, under any color or pretext whatsoever, prohibited, liberty, if not already annihilated, is on the brink of destruction."
Samuel Adams warned in 1776,
"A standing army, however necessary it may be at some times, is always dangerous to the liberties of the people. Such a power should be watched with a jealous eye."
Noah Webster, writing in 1787, argued,
"Before a standing army can rule, the people must be disarmed as they are in almost every kingdom of Europe. The supreme power in America cannot enforce unjust laws by the sword, because the whole body of the people are armed and constitute a force superior to any bands of regular troops that can be, on any pretense, raised in the United States."
In 1788, Brutus wrote of the inherent danger of standing armies.
"The liberties of a people are in danger from a large standing army, not only because the rulers may employ them for the purposes of supporting themselves in any usurpations of power, but there is great hazard that an army will subvert the forms of the government and establish one according to the pleasure of their leader."
This fear of standing armies and their potential for tyranny extends back centuries. In The Art of War, 1532, Niccolò Machiavelli cautioned
that a prince who relies upon mercenaries must either remain embroiled in wars or risk overthrow when the mercenaries become unemployed with the advent of peace.
Even George Nicholas, who doubted the Constitution would pass, emphasized the need for defense through either a militia or a standing army, but he cautioned against the dangers of a standing army.
The dangers of such an army are so striking that every man would oppose the adoption of this government, had it been proposed by it as the only mode of defense.
Thanks for tuning in. In our next video, we'll dive into the historical and legal distinctions between the National Guard and the traditional militia referenced in the Second Amendment. Is the National Guard truly the well-regulated militia, or does the Founders' vision extend beyond it? We'll explore the 1903 Militia Act, key Founding Fathers' perspectives, and why the idea of a citizen militia remains relevant today. See you in the next episode.